Hi, this is Josh Blackman. I am the president of the Harlan Institute, and it's my honor to welcome you to the 2022 Harlan Institute Ashbrook Virtual Supreme Court competition. This year, we're mooting the case of Students for Fair Admission versus the University of North Carolina. This is the fifth match of the semifinal round. For the petitioners, we have Win Conger and Lighthouse Wu from the Baldwin School in Pennsylvania. And from the respondents, we have Bianca Flores and Elizabeth Alvarez from Creekview High School in Texas. Petitioners, you may begin whenever you are ready.
Thank you. Mr. Chief Justice, and may it please the court. My name is Lighthouse Wu, and I, along with my co-counsel Win Conger, will be representing Students for Fair Admissions, the petitioner in today's case, and we will reserve 5 minutes for rebuttal. Would the court like a brief summary of the facts?
Yes, please.
In 2014, the petitioner, Students for Fair Admissions, filed a suit against the University of North Carolina over the affirmative action policies and its admissions process, alleging that the inclusion of race in the admissions process is inherently divisive and discriminatory on the basis of race, and therefore contradicts the guarantee of equal protection and equal treatment in the 14th Amendment. After several years of litigation, the district court ruled in UNC's favor. Following appeal, the case Students for Fair Admissions versus University of North Carolina then advanced to the U.S. Court of Appeals in the Fourth Circuit, and the Supreme Court granted certiorari.
This court should revoke its decision in Grutter v. Barringer as a violation of both the 14th Amendment Equal Protection Clause and the 1964 Civil Rights Act. The original intent of the 14th Amendment was to enact temporary provisional policies for African Americans freed by the 13th Amendment until their citizenship was officially secured. The Civil Rights Act of 1964 further forbade discrimination on the basis of race in federal institutions. The original text of the amendment, history, and tradition therefore all affirm the importance of race neutrality in education, but Grutter fundamentally deviates from the court's equal protection jurisprudence, as established also in Brown v. Board of Education.
Let me pause you right there, if I can, please. So you're saying that Grutter was a deviation from Brown. Is that your position?
Yes, Your Honor.
And Bakke as well?
Yes, Your Honor.
So all those opinions, which stretch back 50 years, are inconsistent with like the Supreme Court's most famous case of 20th century, Brown. Is that your position?
We believe that Bakke and Grutter in all cases affirming the inclusion of race in admissions, which inherently makes the admissions process divisive and discriminatory, violate the equal protection jurisprudence that this court enshrined in Brown.
How could all those judges be so wrong for half a century?
In Brown, Your Honor, in Grutter v. Barringer, Grutter v. Barringer should be overruled because, as the recent case of Dobbs v. Jackson in a women's health organization, the majority aptly concluded that the doctrine of stare decisis, as Your Honor would have mentioned, did not require the continuation of the court's previous precedent. Now, in Dobbs v. Jackson's case, it overturns the precedents in Roe v. Wade and Planned Parenthood v. Casey. The same incidents would have applied to our case in that affirmative action is not a sacrosanct principle. And even the court recognized in Dobbs, established precedent is not immune to being overturned, and the court inherently has an obligation to strike down those harmful judicial precedents. In effect, it doesn't matter how long the court's precedent has been, and it doesn't matter how many famous judges had made the decision. Just as Brown overturns Plessy and Dobbs revoked Roe v. Wade, those decisions, as long as a precedent as Grutter is antithetical to the court's longstanding jurisprudence of equal protection and racial equality on the law, it must be struck down accordingly.
Thank you, Counselor. Let me ask you another question. We often talk about precedent. Let's talk about history. talk about some of the legislation, some of the federal laws that were passed in the 1860s after the Civil War, and how does that legislation affect this case?
Your Honor, legislation such as the Freedmen's Bureau, which provides resources, services, and land to freed African Americans, helped inform our interpretation of the founders' beliefs that the 14th Amendment should and does inherently embrace race neutrality. The 14th Amendment was principally dispatched as a temporary measure, dated the transition of formerly enslaved African Americans following the Civil War, and was swiftly.
I'm sorry to interrupt you, counsel. You said temporary once, you said a few minutes ago, so temporary. Why do you argue that the Reconstruction legislation was temporary? Why do you argue that this is only for a short period of time?
Your Honor, the 14th Amendment, as well as the legislation during the 80s, 60s, and the 70s, are built primarily in purpose to act as a remedy for the freed people, for the previously enslaved African Americans, because they were so oppressed under the systematic racial discrimination. They have to have some form of governmental help in securing their citizenship and their livelihood, essentially.
So if it was temporary, I'm sorry to interrupt, counselor. If it was temporary, when did that period wind up? What year? 1880, 1890? When did that period wind down?
I believe the period of the Freedmen's Bureau Act winded down only a few years after it originated, as the framers originally saw the Bureau as this unwarranted expansion of federal power and a significant contradiction to the doctrine of race neutrality.
Only that lasted a couple of years, the entire 14th Amendment. That's as far as you got?
It only lasted, it was originally meant to be a temporary legislation that, following the freedom of the formerly enslaved African Americans, is meant to ease their transition into citizenship.
Yes, and the framers of the 14th Amendment also deemed the Freedmen's Bureau Act as essentially an unwarranted use of federal government power, and it should only exist so long to promote racial equality during a special time period. And only after a few more years, all such measures were intended to be temporary. Therefore, they.
Let me ask another question. You keep speaking about, preferences for African Americans and other Black Americans. Are other racial minorities able to get any sort of racial preferences, or just Black people?
Your Honor, if we are talking about the time period during Reconstruction, it is certain that the 14th Amendment, as well as various measures such as the Freedmen's Bureau Act, only targeted African Americans and other ethnic groups, while also disadvantaged in living in the United States as citizens. They did not have as much suffer as intended by the framers as the previously enslaved African Americans.
So let me ask you this question. Should universities today be allowed to use any racial preferences for groups who aren't Black, maybe Hispanics or Indians or anyone else?
No, we principally say that the usage of race in admissions contradicts the fundamental doctrine of the 14th Amendment, which is race neutrality. Ultimately, we can conclude that although, like the situation, for example, of Hispanic Americans or American Indians, and differed at the time of the 14th Amendment, the doctrine of the 14th Amendment and the text enshrine race neutrality.
All right, so let me ask you a hard question. Let's say that after we rule in your favor, we overrule Grutter, we overrule everything, and universities come back and their entry classes are basically all white and Asian, right? There are no, imagine 2 Black kids on the college campus, and the schools say, we need to use race, we need to do something. What's your response to that?
Your Honor, if in your hypothetical, I'm sorry, could you repeat the question?
So let's say we rule for you in every regard. We give you everything you want. We rule Grutter. And then the universities go to, race neutral, maybe they consider socioeconomic, but their entry class is all white, maybe white and Asian, perhaps 2 Black kids in the entire college campus. And they come back to the court and say, we need to use race. What's your answer?
Your Honor, in this case, in your hypothetical, certainly it might appear as the diversity on campus in the student body is not achieved without the use of affirmative action. However, nobody's 14th Amendment right is violated because the 14th Amendment only and principally guarantees the equal protection of all citizens under the law. Therefore, even it might appear that the university's diversity in student body, the racial and ethnic diversity is not probably exhibits as much as before. However, nobody was as long as nobody is denied of their application or nobody gets a certain more than just a merit plus in their application process because of their race.
Thank you, Counselor. Your time is up. Thank you so much. I know you want to finish your sentences, and law students know that commas and semicolons run on forever, but like all things must come to an end. Thank you so much. Respondents, please come on camera and you'll have your 15 minutes. Okay, whenever you're ready, you can begin.
May it please the court, my name is Bianca Flores, and along with my co-counsel Elizabeth Alvarez, we represent the respondent, the University of North Carolina, in today's case. The question presented to the court today is, should this court overrule Greta v. Bullinger and hold that institutions of higher education cannot use race as a factor in admissions? This court should rule in favor of the respondent for the following reasons.
The 14th Amendment does not prohibit state universities from using race-conscious affirmative action. Therefore, race-conscious affirmative action is consistent with the 14th Amendment of the United States Constitution. When looking at United States history, the 14th Amendment was written to serve and protect the rights of freedmen following the issuing of the Emancipation Proclamation. In siding with petitioner, the court would be essentially neglecting the purpose that the 14th Amendment was written to serve, and the compelling interest of diversity should be found to be applicable to race-conscious affirmative action in our case, as it ensures a critical mass of students from minority groups. Additionally, the education system has actually benefited through a diverse student body. And finally, race-conscious affirmative action is comparatively the best option to turn to when seeking to increase student body diversity.
Moving to our first point, it is a fact that the 14th Amendment of the Constitution was passed in order to tackle Black codes. Furthermore, after the establishment of the Emancipation Proclamation, the United States government sought to provide a remedy for freed slaves. Representative Sumner claimed that the curse of slavery is still upon them. Someone must take them by the hand, not to support them, but simply to help them to that work which will support them, and that the intervention of the national government is necessary when speaking in favor of freedmen in the first session of the 38th United States Congress. An example of a remedy was sought to be provided in the form of university education, something that the majority of African Americans did not previously have access to in the United States prior to the Emancipation Proclamation.
If I could just jump in for a minute. Your friends on the other side, acknowledge legislation like the Freedmen's Bureau Act. They say it was temporary in nature. Can you address that argument, please?
Well, Your Honor, it is important to note that the efforts to provide remedies to minority groups should not be limited to past events. Moreover, when looking at today's circumstances, many struggles and injustices that minority groups such as African Americans have to face are yet to be resolved. For instance, racial discrimination is still prominent in our society, and minority groups still have lesser access to higher education compared to other groups. Further, race-conscious affirmative action is one step towards resolving.
If I could ask a question for Elizabeth. When we're dealing with history, and we have this specific history of discrimination towards Black Americans, how can we then extend it to other groups who didn't face similar persecution at the time the 14th Amendment was ratified?
Well, Your Honor, although in the year 1865, the Congress passed an act to establish a Bureau for Release of Free. Well, Your Honor, although they weren't enslaved, they were still heavily discriminated against, and we can still see those effects that are very much still prominent in today's society. And
Let's say that there's someone who's an African immigrant who is not even in the United States in the 1860s. He immigrated to the United States in the 1950s. Can this person avail himself of these sort of preferences?
yes, Your Honor, because they do not have the resources and stability that other groups
What if they're
may
wealthy?
have.
What if they're a wealthy Nigerian oil baron and they have lots of money? Should they avail themselves of these preferences?
Yes, because diversity is a very important thing to have in higher education.
All right, let me ask a different question. And I'm sorry if Justice Davis or Gus want to jump in, I'll open up.
Sure, I have a quick question regarding the temporary aspect of these admissions processes. It seems like they are trying to fix some sort of racial injustice that has been done to Black and Hispanic students. How do we measure the point when we would no longer need these processes, or is it indefinite? Will we always be able to use these admissions processes?
Well, Your Honor, although some progress has been made in achieving racial equality, this court must note that progress has in fact slowed, and further significant progress might not be achieved for a while, perhaps another 10 years.
Is there a certain percentage of these certain student groups to where we can consider that the job has been accomplished, that we will no longer need it?
No, Your Honor, I don't think we should be looking at numbers to see the progress within diversity. I think diversity is a case-by-case basis, and every university is going to have a different aspect of what diversity is for them.
I've got a quick question regarding some of the policy reasons why we want to give these plus factors for minorities. It sounds like you're arguing that there are less opportunities given to minorities, right? And that there's socio-economic issues at play. Is that correct?
Yes, Your Honor. To a certain extent, many minority groups are more likely to be social economically challenged and underrepresented in higher education, unlike other groups.
Okay, so why don't we just give plus factors based on socioeconomic factors versus the factor of race? If the concern is about giving greater opportunities to those who don't have the socioeconomic status, why don't we just focus on that as opposed to race?
Well, Your Honor, to discount race as a form of diversity neglects the experience that could be offered to a widely diverse group of people. For example, even if there was a solely white student body with a wide range of socioeconomic backgrounds, there would still undoubtedly be something missing. Furthermore, in Fisher, the university tried and failed to increase diversity through enhanced consideration of socioeconomic and other factors. The court in Fisher also noted that no other proposed alternatives was a workable means for the university to obtain the benefits of diversity that it sought.
Why is it important?
Go ahead.
I was just going to ask, why is it important to have diversity on campus?
Well, Your Honor, to discount race as a form of diversity wouldn't permit us to be able to see a person as a whole and to take regards into what they have experienced and what they have faced throughout their lives.
To clarify, is your argument that student body diversity is a compelling interest or racial diversity?
Well, Your Honor, we are trying to contend that under compelling state interest, that the interest to attain student body diversity is compelling state interest, and therefore it should be permitted when looking to race-conscious affirmative action.
Let me ask a question, Counselor. Sorry, I was on mute. Let me ask a question, Counselor. Let's say, we have these racial preferences policies, and there are only a fixed number of seats at any university. Let's say the freshman class is 1,000 students. If you're admitting some students based on their race, then you're necessarily excluding other students because they're not of the right race. How do you respond to that argument?
Well, Your Honor, critical mass is completely different and distinguishable from a quota.
You're right. I'm not saying anything about quota, but just if there's 1,000 students and some students are getting in part based on their race, the other students will not get that benefit. So how do you respond to that? I mean, there's some evidence that white students and Asian students are treated worse than other minority students.
Could you rephrase that question, Your Honor?
There's some evidence that Asian students are treated worse than some other minority students with regard to admissions. How do you respond to that?
Well, Your Honor, it is important to note that compared to some specific minority groups, underrepresented minority groups, Asian Americans have not faced the same amount of historical discriminations.
I'm gonna have to stop you right there. We've had internment in this country. People still alive were in internment camps. That I don't think that's quite right.
Your Honor, Asian Americans are more adequately represented in universities' population, more proportional to the states or the country as a whole, unlike other groups that are underrepresented.
Right.
But if there comes a time where one group is more overrepresented than another group, are we not punishing them for some sort of academic success? Because if they're overrepresented, or whatever word you want to use for it, the only remedy with that would be to admit less of them.
Well, Your Honor, we are simply trying to contend that the school should look to admitting more underrepresented minorities, especially when considering the fact that they can contribute to attaining further student body diversity. Moreover, Asian Americans do not face the same amount of injustice and discrimination that other minority groups have faced.
How on earth do you measure that? I mean, what if there's a first generation Chinese immigrant whose parents work 80 hours a week, and then you have a wealthy African American family in the suburb of Dallas? You know, who are you to say that one faces more injustice than the others?
Well, Your Honor, the 14th Amendment was initially passed to tackle Black codes and to furthermore, the Freedmen's Bureau was passed in order to remedy previous injustices that African Americans have faced. Therefore, we should look to that when looking to the context of our case.
But so then what about American Indian Hispanics who are not the subject of those Black codes? Do they get the preferences?
Well, historically, they have also faced significant racial discrimination in the way that they have, as a result of expansionist movements, they have
All right. You can move on.
been forced out of their land. Okay.
You can move on.
Moreover, the compelling interest of diversity is one that should not be dismissed when looking at the facts of today's case. Historically, racial minority groups such as Hispanic and African American groups have been clearly discriminated against in this country. Furthermore, this court should also acknowledge that in the past, the United States college education system has failed to properly represent the country's minority populations and its student bodies. For instance, only a small percent of Hispanic high school graduates were attending college in the year 1990, according to a New York Times article. Furthermore, in the case of Bakke, the University of California Davis School of Medicine relied on a strict racial quota in order to diversify their student body and increase the population of minority students at their school. That court also ruled that such racial quota is impermissible. In our case, however, there is no presence of such quota, and the university's admissions process is in fact clearly distinguishable from such a hard line. Furthermore, in our case, the University of North Carolina.
I'm sorry, Councilman Interrupt. Could you tell me a little bit about Justice Harlan's dissent in Plessy versus Ferguson?
Well, Your Honor, Plessy was wrong in ruling that separate but equal is constitutional. Furthermore,
what was Justice Harlan's dissent in that case? What did he say?
It was nothing more but a legal theory, and he ruled that it was separate but equal.
What did Harlan say about our Constitution? Are you familiar with the dissent or no? That's okay. Well, Justice Harlan said in his Plessy dissent that our Constitution is colorblind. That's a very famous line. Do you think our Constitution is colorblind?
Well, Your Honor, I When looking to Justice Harlan's dissent, it was nothing more than just a legal theory, and furthermore, in Brown v. Board in Brown's decision, it actually overruling of Plessy, it didn't mention anything at all about Justice Harlan's dissent, and therefore we shouldn't
I don't think
look
that's
to it, and it is not from it.
I don't think that's quite right, but move on. You can about 30 seconds. You can wrap up.
In the case of Bakey, the University of California Davis School of Medicine relied on the strict racial quota in order to diversify their student racial quota is impermissible. In our case, however, there is no presence of such racial quota, and the university admission process is in fact clearly distinguishable from a hard line. Furthermore, in our case, the University of Carolina's race affirmative action should pass the constitutional muster, as it doesn't set a strict racial quota for minorities. Instead, the university actively recruits minorities and seeks to include them in racially and culturally diverse student body. A racially diverse student body then benefits from the inclusion of students from groups which have been historically discriminated against.
Thank you so much, Counselor. Okay, excellent. All right, so now we have 5 minutes rebuttal from petitioners, please. Whenever you're ready.
In contrary to the opposing counsel's belief that race-conscious affirmative action is against, not in line with the 14th Amendment, the opposing counsel kept mentioning the diversity in students' body. However, it is very hard, almost impossible to define what diversity is in the first place. When the opposing counsel was talking about trying to define diversity, they used the wording multiple times that African Americans should be inherently have an advantage over other ethnic groups because of continual societal oppression and the hardships that the ethnic group has. However, there are also other minority groups that wouldn't be considered under the current affirmative action policy. And even if all the minority ethnic groups get a plus during their admission process, let's say, it's still against, in contrary to the 14th Amendment, because it's violating.
So again, let me try this again. So we have evidence that the framers of the 14th Amendment were comfortable with racial preferences for the Freedmen's Bureau Act. Why should the Supreme Court now come along and say, no, universities, you can't be doing what you're doing for a long time? Why is that the right approach if there's a history we have to contend with?
Your Honor, it is the court's responsibility to strike down harmful precedents, especially during this time when race-conscious affirmative action is no longer needed.
We'll also note that in line with the Grutter prediction in 2003, only a quarter of a century later, we have achieved a level of educational diversity that no longer makes racial diversity.
But UNC disagrees. I'm sorry to interrupt, but UNC says we haven't achieved that yet, and we're still not there yet. Shouldn't we have some deference to universities who are on the ground? We're just judges. What do we know?
I'm sorry, is that the question?
Yes.
Okay. In achieving student body's diversity, there are race-neutral alternatives the UNC can apply. Unfortunately, as we see, UNC has rejected those alternatives and still choose to use race as a factor during students' application process, which in their use, even there's not a definitive quota as in other cases when we see, because achieving the so-called student body diversity is such a compelling interest during their application process, it essentially acts as a quota.
Let me ask you some policy questions. For example, the military, right? The military says it's very important to have diverse members in order to have a diverse officer corps, right? The leadership. And there's something of a pipeline from universities to the military to the officer corps. If we rule that universities can't use affirmative action, wouldn't that impact our military preparedness and the ability for us to defend the nation?
No, Your Honor. Notably, the military itself is already a diverse student body, currently even more so than UNC.
But they can
But-
use affirmative action though. If we rule against the Grutter precedent, they might have to change what they do.
However, we believe that they can still maintain levels of racial diversity throughout the Army, Navy, Air Force academies, as well as college and universities that offer ROTC programs through race-neutral alternatives, which offer positive, constructive methods for achieving and maintaining diversity without discriminating between applicants with the use of race. For example, Students for Fair Admissions propose geographic recruitment from a socioeconomically diverse.
What if,
variety
again,
of areas.
what if in, let's say in 3 years, they come back and say, we've tried socioeconomic and we still have entirely classes white and Asian kids. Can we come back and say, maybe we were too harsh, but we should consider, a different standard?
Your Honor, we can certainly, in that case, we can certainly choose other alternatives to make sure that a diverse body of Army soldiers would be achieved. However, it doesn't mean that we have to go back using a race-conscious affirmative action just because if such harmful policy is in effect, the number of people will get disadvantaged and their 14th Amendment right would be violated.
I've got a quick question about what this looks like practically. So if a student wants to talk about the discrimination that they face, they've personally faced racial discrimination growing up, can they address that in their personal statement with their application?
Yes, Your Honor. As long as for example, as long as the university evaluates the content of the personal statement for the character and experiences of the applicant as opposed to their race, then yes, this is possible.
Okay, thank you.
For instance, okay,
And-
race
and-
that
and-
most. Okay,
Finish your sentence, that's fine.
okay.
We're
We're-
fine. Thank you, Your Honor.
Thank you, Your
That's
Honor.
fine, thank you. Yeah, okay. The case, the case is submitted if the respondents, please back on camera, please. Let me say to you all, congratulations. This is not an easy case. It's a very difficult case, and it requires drawing some very difficult lines. And these are lines that don't always follow easily from legal principles. These are lines that often follow from policy questions, policy disputes. And I gave the petitioners and respondents a very hard time on this question. And I think what this case forces you to do is to reconsider things that you've always sort of taken for granted. You sort of just parrot whatever you hear in school about, these issues, but we're really pushing you to define why things are the way they are. And I thought both teams did very strong. What I liked is you all had very good tone, very good pacing. You were clear. I understood every word you said. Everything was very easy to understand. You had, I think, a very natural handoff between one part to the next. It was very smooth. You didn't try to throw your partner under the bus. You had a very, it happens. You had a very gentle handoff between one and the next. If one member was kind of stumbling, also it happened that I asked you stuff you didn't know. It happens. No matter how hard you prep, and you said, Your Honor, I don't know. That's fine. You're allowed to do that. In fact, it's better to say you don't know than start making stuff up. That's when you get yourself in trouble. Mick is smiling, right? You start making stuff up, you are in trouble, my friends. Also, I think you didn't get exasperated, right? A lot of the questions we're asking you don't actually have good answers. They don't. If you listen to the oral argument at the U.S. Supreme Court of these two cases, of the Harvard case and UNC case, the lawyers, they were scrambling. They were squirming like a little fish flopping around. You listen to it, yeah, it's not pleasant. So if you think, oh my God, what am I going to say? You're in good company because the actual lawyers really had a hard time. And also, I think you were having fun. I mean, maybe I'm biased, but it seemed like you were kind of enjoying it. This is what lawyers live for. And both of my colleagues are on the moot court team at the law school. This is fun stuff. When you get in front of a very hot panel, which means we're asking lots of questions, you're really saying, okay, how do I know this stuff? And you know it well. So I want to say congratulations to you. And also, if Mick or Daniel have any comments, I'm happy to hear their feedbacks.
Yeah, I'll jump in first. Yeah, great job. Y'all are already, beyond so many people who do their first argument. I don't know what your experience is with this, but y'all should stay after it because you have some skills here. And to piggyback off of Professor Blackman says, this is an extremely difficult issue, especially on the respondent side. But there's some tricks that you'll learn as you do this more, that when you have a weakness in your argument, it's okay to acknowledge your weakness a little bit, but then pivot back to where your strengths are. And so, the North Carolina side, the strengths is definitely the policy, and y'all hammered that. And then with petitioner, y'all went to the history, said, those racial preferences aren't needed anymore. That's exactly what you did. And so great job. My one critique is, and this is a problem I have. I just got done competing in a tournament where I've caught myself doing it, is that you focus so hard on memorizing your argument that you lose the questions a little bit. And so it's really, really important that when you get questions, you listen to them carefully, and without just going back to a place where on your script, you try to answer the question directly. And again, it's something that I still struggle with, and I've done, at least 10 moot court tournaments now. But if you can directly answer the questions, that will really serve you well going forward. But great job, and that was a lot of fun for me too. So thank you,
Daniel.
Piggybacking on what Nick just said, make sure on some of y'all's questions, make sure first thing that comes out of your mouth should be a yes or a no to, or I don't know, do whatever the judge asks you. Then you can go on and bring up whatever arguments you may have to support it. But judges really get irritated when you don't give them a finite answer, and that kind of opens the door to a bunch of unpleasant follow-up questions. But y'all did tremendous jobs. You're way ahead of anywhere I thought high schoolers could be. It's very impressive to watch. So please stick with it. It's very fun to be a part of it.
Awesome. Let me just get some more concrete feedback. What Daniel said, answer questions yes or no. Absolutely. At one point when I asked you a question, you answered with however. Like you anticipated the question and said, however, Your Honor. There was actually you're on the right track, but you have to give a yes or no at the outset. A couple times, this are both teams. When I asked you a question, it seemed that you were pivoting to something you prepared in advance. Now, I can't see if you're reading from a screen. Maybe you are, maybe you're not. I can't really see. But at least it felt like you were giving me a canned answer. And those don't taste well at oral advocacy. I think Mick and Daniel will attest to that, right? When there's a question that's very precise, you have to sort of go on the fly. There were a couple times I asked questions which I thought were pretty clear, but you didn't understand them. And then maybe there's some, technical reason why, but there's no problem with saying, can you please repeat the question? But it sort of kills the judge's steam when he comes, it's like a really long wind. It was like a 30-second question. And then I didn't remember all the various parts of my question either. So maybe you can practice when you go home, watch this later on YouTube, to just sort of listen to the question and say, oh, I probably should have gotten in the first go. Because I get it, you're nervous, right? There's a lot going on, your head's spinning. You're really trying to follow along. But very often the questions won't be, very short. They'll be long because judges are trying to, we're trying to set you up, right? We're trying to set you up to give you all these different facts. And we want you to answer these specific things. And if you say, I don't understand the question, it sort of kills the question because you don't remember what you were even asking anymore. What else? Dan, Mick, anything else you want to mention? No? Okay, do you have any questions for me? Anything, or Mick or Dan, about law school, the tournament, anything else in your mind?
Mr. Blackman, I heard you told us the story about you becoming a lawyer last year as we did this tournament last year, but I forgot about it. So, well, I already said it to you once today, but I'm going to say it again. Could you repeat?
Oh, you're funny. I like that. You're very, no, I like that. She's funny. It's good. I'm happy to. So and I'll let Mick and Daniel tell their stories of how they came to law school in a few moments. I went to school at Penn State, which is probably not too far from where you are. Where are you? You're Central Pennsylvania, Eastern? Where are you?
Yeah, around the Philadelphia area.
So not too far. My degree was computer science, so nothing at all with what I do now. I went to work after I graduated at the Department of Defense in Washington. And then I started off as an evening student at the George Mason Law School, which is in Arlington, which is not too far from where I worked. And I really enjoyed law school and I loved it. And after I graduated law school, I clerked for 2 judges. Clerking is it's like a short-term temporary, if you will, a temporary position. We work for a judge for a short period. I spent 2 years clerking for a judge in Western Pennsylvania in Johnstown, almost to Pittsburgh, the other side of the state. And then I spent another year clerking for an appellate judge in Louisville, Kentucky. And then I started teaching at the South Texas College of Law in Houston, which is much closer to my friends in Creekview. I'm right in Houston. I started teaching there in 2012, and I've been blessed to be teaching there since. Is that the story I told you last year? I don't remember what I told you last year. I'm
It
sorry.
sounds pretty different, actually. Are you lying?
No.
It's all true. Okay.
Told you. What did I say last year? I don't remember.
I don't know, but it doesn't sound completely the same. So, but it's okay. Sometimes it's like,
We got a prior inconsistent statement going on here.
I don't want to deposition this one. Okay. What did I
Being
say?
clarify the record. I don't know what's going on.
Yeah,
You know what? Maybe. Let me tell a variant of it. The longer version. I had no idea what I was doing. Maybe this is the part you heard. I had no lawyer family. I didn't know what I was doing. When I got to law school, I didn't know what a 1L was, a first year law student. I didn't know anything. I was completely overwhelmed. My first year law school was not the strongest. I finished middle of the class, but then I started figuring it out, and I graduated top of my class. So that what I told you, I can't remember. No. Oh man,
getting closer.
I'm getting impeached by a high school student, man. This is Nick and Dan. How did you guys come to law school? You're not done yet. You're still in the mix, but how did you guys get to law school?
I came to law school because I was working for state government before law school. I worked at the state capitol for a state senator here in Texas, and then worked for a state agency. And I found that there were limits to what I could do in the government without a law degree. And that there were certain capabilities that other people had that I didn't have because I didn't have a law degree. So my initial plan was just to go to law school, just to come right back to Austin, Texas, and keep working in politics and state government. And then once I got here, I found out that there's a lot of really interesting stuff about the law that doesn't just revolve around government and politics. And so that's kind of how I got here. And I came to South Texas specifically for the moot court program. They do an excellent job of marketing. And when you came to their website, they show all the trophies and whatnot. And as a big sports guy, that kind of fired me up. And so that's why I came to South Texas.
Daniel?
Yeah, I grew up and my dad was an attorney, but I truthfully never had an interest in going to law school for most of college, honestly. So I was involved in a pretty lengthy litigation involving extended family, and getting to work close hand with attorneys like that, it was a really cool process, and it more or less inspired me. One, because like what Mick said, having a law degree in the professional world is invaluable. It opens so many doors to be able to do so many different avenues. If even if you don't want to specifically litigate cases or be in the courtroom, it opens up so many different avenues that you can do with your life. So I think having a law degree is one of the most valuable professional degrees out there.
What are our friends in Creekview? You guys have any questions?
We were wondering when like the videos were going to be posted.
Probably Thursday or Friday will be posted.
Okay, thank you.
Yeah, I wait till all the rounds are concluded before I post the videos to avoid giving the teams on Thursday an advantage of what they saw on Tuesday. That's part of the reason why I do that. I used to actually live stream them. I forget all the other teams were watching. It's like, so I try to avoid posting until after Thursday. How many of you are interested in law school again? Any of you interested in law school? 1, 2, maybe.
Law policy.
Policy, okay. Policy's
aren't you
good.
doing international relations?
A bit of international, a bit of local policy.
All right, very good. Anything else in your minds? Anything else we can answer for you? No? Well, congratulations. This was not maybe it was, well, maybe it wasn't pleasant, but I hope when you look back, you'll think of this experience fondly. You'll enjoy it more when you watch it later, I promise.
Last year was worse.
Last year was worse. Why? Because you didn't know, now you know what you're doing?
You, when upon opening, you asked us about the statue of Northampton.
Oh,
And we have no idea what it is. So,
Did
yeah.
When you watch these videos, I've never watched a video of myself or left an oral argument and been like, I crushed it. Like you will never feel that way.
No.
So it's okay to be critical of yourself, and when you watch it, like see ways you can improve on. It's better than okay. It means that you're learning and you're self-aware. You know how to get better, which is the most important thing.
Oh,
thank you.
No, it's true. It's I watch when I teach a class. I'll sometimes watch my class afterwards, say, man, that sucked. I did not hit that point, and I'll try and do better again next time. You always learn from your experience. Trust me, you learn. All right, everyone. Thank you so much. If you're ever in Houston, you're welcome to come visit my class. If not, you can email me. And Lidas, if you don't believe me, I can send you a copy of my transcript and my birth certificate, whatever else you want to see. I have all my documentation.
okay.
Tax returns. When was your tax returns?
Go on my
Okay,
tax returns. Oh my goodness, I'll give you a DNA swab, whatever else you need.
bye,
All right.
guys.
Take care, everybody.
Bye.
Bye.
All right, and the
Have a good
judges sit
night.
down for a minute. Thank you. Good night. I'll talk to the judges for a bit.